Good afternoon, everyone. I would like to welcome you all to the Dakota Dilemmas Navigating the Complaint Process Extended Cut version. I want to thank all of you for taking time from your schedules to join us today and continuing to learn about ethics laws in North Dakota. So in 2024, the North Dakota Ethics Commission created the Dakota Dilemmas webinar series to educate the public as well as lobbyists, candidates for office, and state officials about the commission and how it meets its constitutional obligations. That year, we hosted the OG, Navigating the Complaint Process webinar, and we walked through each step of the process. However, during the most recent legislative session in 2025, the Legislative Assembly amended that process. It added additional steps, renamed terminology, and we saw significant revisions to the confidentiality constraints on the process. The Commission subsequently updated its rules to bring better clarity, consistency, and workability to that process. So just for reference, if you want to review the legislative changes to the complaint process, you can find those in Senate Bill 2004, which was the Ethics Commission's budget bill. And then the Ethics Commission's rules that we are referring to today that relate to the complaint process, those can be found in North Dakota Administrative Code Article 115.02. If you want to go back and review those in further detail after the webinar, we encourage you to do that. So as a result of these changes that happened in 2025, today we are bringing you the extended cut version of navigating the complaint process, really to build upon what we covered in the original webinar and then to talk about those specific changes that happened. So my name is Rebecca Binstock, and I have the privilege to serve as the Executive Director for the North Dakota Ethics Commission. With me today is Logan Carpenter, who serves as General Counsel for the Commission. Mr. Carpenter and I will be co-hosting our webinar today. We'll jump back and forth on some slides as we walk through this process. If you happen to have questions along the way, you'll notice there is a chat feature. You can go ahead and pop your questions in there. Once we get to the question and answer portion of the webinar, we'll circle back to those and answer those to the extent that we can. I do want to note before we start that while both Mr. Carpenter and I are attorneys, we are not your attorneys for the purpose of this webinar. This webinar is to provide general education. It is not advice on a specific matter. Neither Mr. Carpenter and I have an attorney-client relationship with you as the audience, and our public educational presentations are in no way subject to any attorney-client privilege. The Commission and its staff may, in fact, have an adverse interest to those who violate ethics laws. Finally, just another kind of note, if you do need legal advice, you should seek your own counsel. So with that, let's dig in to the complaint process extended cut. Now, before we jump into the actual process that we're going to talk about today, we want to reintroduce you to the commissioners and introduce you to some new faces that have recently joined the Ethics Commission. So if you look at your screen, commissioners are appointed by consensus agreement of the governor, Senate Majority Leader, and Senate Minority Leader. We have 5 current commissioners who serve on the commission, including Chairwoman Dr. Cynthia Lindquist of Grand Forks, Vice Chair Ron Goodman of Oaks, Pam Sharp of Bismarck, Mark Western of West Fargo, and Jared Hubrights of Mandan. Many of these, 3 of them, Commissioner Sharp, Commissioner Western, and Commissioner Hubrights, are new to the commission just within the last year. So we wanted to just show their faces so you guys have an opportunity to know who they are when you see them out and about. Now let's go on to what are we going to be talking about today during the hour that we have with you guys. So our focus today is going to be on the complaint process for the commission to receive and investigate complaints. And again, as I've said, we're going to build on what we covered in our 2024 webinar on the complaint process. If you want to go back and review Article 14 of the North Dakota Constitution and the Commission in more detail, we'd encourage you to review our past webinars that can be found on our YouTube channel, which you can access through the North Dakota Ethics Commission's website. Article 14 of the North Dakota Constitution directs the Ethics Commission to, quote, investigate alleged violations, end quote, of state laws related to transparency, corruption, elections, and lobbying. In 2019, the year after the commission formed, the Legislative Assembly created a statutory complaint process for the Ethics Commission when it receives a complaint that alleges a lobbyist, a public official, a candidate for public office, political committee, or contributor violated one of those laws. Today, we're going to review how a complaint is filed, how a complaint is processed and investigated by the Ethics Commission, all the way from initial receipt to resolution. Importantly, we're going to talk about the roles of the complainant, the respondent, and the commission along the way. We're going to cover the new added steps that were added in 2025, as well as additional updates to the rules that have happened since our last complaint webinar. You will notice on the bottom left corner of some slides, you're going to see a new sticker. These are slides that you're going to want to pay particularly close attention to because they contain changes that have happened. You'll see those along the way. So, what are we going to cover today? First thing we're going to talk about is setting the stage. We're going to discuss the terminology that applies in this complaint process, and we're going to discuss who a complaint can be filed against. Next, we're going to turn to confidentiality. There is some nuance in this area, so we're going to discuss the strict confidentiality that's imposed on this process by statute and the revisions that happened to this in the 2025 legislative session. We're going to talk about the filing of complaints, how a complaint can be filed with the commission, and who can file one. Then we're going to walk into the 4 steps of the commission's process. The process to initially review it, to settle it potentially, to investigate it, and then to eventually take commission action, which is our number 5, which is complaint resolution. We're going to discuss what happens after an investigation is completed and how the commission has updated its rules to structure this commission action process. So with that, let's start by talking about important terms that we need to know along the way. These are kind of our baseline definitions as we talk about the complaint process. These are important terms. You're going to hear them throughout the webinar today, so we're going to touch on them briefly. There was also a change in 2025 to these. So the term complainant refers to the person who files a complaint with the Ethics Commission. And they're going to file that complaint against a certain individual. So that person is called the complainant. The next definition or term that we want to know is the term respondent. This is the person a complaint is filed against. This is the person who is accused of an ethical violation. You'll notice that the term accused individual is crossed off on your screen. This is the term that was previously used in the statutes regarding the complaint process for the respondent. However, in 2025, the Legislative Assembly amended the definitions to rename accused individual to respondent. So they switched out those terms. Why did they do that? Because the Ethics Commission didn't use this term. In the Commission's rules and in its practices and procedures internally, we've always used the term respondent. The Commission prefers the term respondent because it doesn't have a negative connotation, it is a neutral term, and it didn't prefer the term accused individual because it has this assumption of guilt that's associated with the term accused. So again, moving to that more neutral language of respondent. So the Legislative Assembly adopted that term throughout 5466 of the Century Code. So that's our first important change that happened in 2025. So now that we have our important terms, complainant, respondent, and the Ethics Commission is going to be the Ethics Commission established under Article 14, let's go to who can be a respondent. Keeping in mind, a respondent is somebody against whom a complaint is filed. So there are limitations to who the Commission can receive complaints against. The Ethics Commission's complaint authority is over lobbyists, public officials, candidates for public office, political committees, and contributors. Now, let's talk specifically about that definition of public officials. Who is included as a public official? Elected or appointed individuals in the executive and legislative branches, members of the Ethics Commission, and legislative employees are all defined as public officials. The term public official, however, does not include anyone in the judicial branch. You'll see on our little graphic, judicial is completely crossed out, or executive branch employees, unless that executive branch employee is appointed or elected. Now, for complaints that involve a quasi-judicial proceeding, and quasi-judicial proceeding is something that is an administrative hearing or perhaps a licensing proceeding, something that is happening before not a judicial branch, but something typically in the executive branch. For complaints involving this particular process, Article 14 of the North Dakota Constitution grants the Commission expanded authority. So here, the Commission's authority covers directors, officers, and this is a quote from the Constitution, directors, officers, commissioners, heads, or other executives of agencies who take part in a quasi-judicial proceeding. This could potentially include a non-appointed executive branch employee if that employee is acting as a director, officer, commissioner, head, or other executive in a quasi-judicial proceeding. So if we talk about amendments or changes that happened in 2025, the Commission had to add these quasi-judicial individuals to its definition of respondent in its rules. This group of respondents was actually missed in the statutory definition and in previous iterations of the Commission's complaint rules, so we made sure that those were included in 2025 as a respondent. So now the Commission can process complaints against those individuals. Now, keep in mind the Ethics Commission can only consider complaints against the list of people who you see: lobbyists, public officials, candidates for public office, political committees, contributors, as well as those individuals within that quasi-judicial proceeding. So that is the limit on who can be a respondent. So now that we've talked about a complainant, we've briefly touched on a complainant and a respondent, let's talk about the confidentiality that's kind of overarching to this Ethics Commission complaint process. The confidentiality provisions that apply to the Ethics Commission complaints by statute. This happens by statute. They can be complicated and they can be difficult for people new to the process to understand. So we want to cover those briefly. Under North Dakota Century Code 546612, 3 groups of information are considered confidential related to the complaint process. 1 is information revealing the contents of a complaint. This can include the identity of a complainant. 2 is information that reasonably may be used to identify a respondent. And 3 is information related to or created as part of an investigation of a complaint. So these 3 groups of information retain their confidentiality status until and unless the Commission determines that an ethical violation has occurred and the respondent has either went through the appeal process or has had a chance to appeal. So because of these confidentiality requirements that are implemented by statute, the Ethics Commission cannot confirm if a complaint has been filed with it, and it cannot divulge any identifying information related to a complaint, unless it does so as part of its own investigation. So for this reason, all discussions at Ethics Commission meetings of pending complaints take place during executive session. Another note on the confidentiality is that the complainant, the individual who files the complaint, has the option to remain confidential from the respondent, not only from the public, but from the respondent. If the complainant elects this option, the Commission cannot disclose the identity of the complainant to the respondent. And Mr. Carpenter is going to talk a little bit about the practical implications of that later on. However, there is an exception that if the complainant waives confidentiality, authorizes its disclosure, or divulges information that reasonably may be used to identify the complainant. However, we do want to note that the statutes that govern this type of disclosure of the complainant's information is unclear. One statute requires the confidential complainant to authorize disclosure by the Commission of the complainant's identity, while another statute states that they can simply waive it. So there is some confusion on the statutes there. The Ethics Commission may also disclose a complainant's identity if it's required by law or if it's necessary to conduct an investigation arising from a complaint. Keep in mind also that if a confidential complainant, meaning if somebody chooses to remain confidential, their identity will remain confidential even if the Ethics Commission finds the respondent engaged in an ethical violation. Other confidential information can open up at that point where the confidential complainant's identity remains confidential. Now, another important note is that the Ethics Commission often shares or needs to share confidential information with other entities, specifically public entities, to investigate a complaint. There is a statute in North Dakota that requires public entities, though, to when they receive information related to an Ethics Commission complaint, to maintain its confidentiality. So its confidentiality stays intact. So what happens if a person divulges this confidential information related to an Ethics Commission complaint, where an exception for that disclosure doesn't apply? There is a criminal statute that may apply to public servants who disclose confidential information that could result in a Class C felony. And it's that reason, that function of that potential criminal statute, that motivated a change of confidentiality for respondents. So because of the disclosure of confidential information statute, and it's section North Dakota Century Code 12.1-1301, it precludes public servants from disclosing confidential information. The text of that confidentiality, that potential criminal statute, and the text of the confidentiality statute for the Commission in 5466, it implies that public officials who are respondents cannot discuss or talk about a complaint that was filed against them. This created a lot of stress, frustration, and concern from public officials as they felt that the confidentiality prohibitions really prevented them from defending themselves publicly. The Commission shared these concerns and previously identified these statutes as a potential liability for the state and the commission on First Amendment grounds. So during the 2025 legislative session, the Legislative Assembly amended the text of 5466 to communicate that respondents may discuss complaints filed against them publicly. So that language was changed during the 2025 legislative session. So now respondents can communicate about the complaints that are filed against them. All right, so going back to what happens when a complaint is filed. So we're going to start talking about this process that was developed by the Legislative Assembly, and it has the Ethics Commission receive complaints, process them, attempt to informally resolve them or settle them, and then investigate them if necessary. And ultimately, the commission can make a determination if an ethical violation has occurred under this statutory process. So there are some requirements that we want to talk about for individuals filing a complaint. This is the complainant. Only certain individuals can file complaints. North Dakota residents, individuals who are licensed by a state agency, or licensed by another public official who is subject to the authority of the commission. In this instance, think of somebody who is practicing medicine in North Dakota but lives in Moorhead in Minnesota. They would be able to file a complaint because they are licensed by a state agency. They do not have to necessarily be a North Dakota resident. And then a party to a state quasi-judicial proceeding, they also may file a complaint. Complainants are required by statute to provide their name, address, and telephone number to the commission along with their complaint. So then the question is, now we know who can file a complaint. How does one file a complaint with the commission? So an individual can file a complaint with the Ethics Commission 4 different ways. 1, by phone. Article 14, Section 3 of the North Dakota Constitution requires that the commission maintain a confidential whistleblower hotline. That confidential hotline number is 701-328-6000. The commission maintains that pursuant to the Constitution. There's also a corresponding email that goes along with that, which is ethicshotline@nd.gov. So the commission can receive a complaint, or somebody can file a complaint either by phone, by giving us a call. They can do so in writing. Sometimes we receive these by snail mail or by regular email. You can do it in person. You can stop in our office and have a discussion, or you can do it on our website by filing a complaint form. Filing a complaint form or submitting a complaint form on our website is the preferred method, as it walks everyone through the information that's required to submit a complaint, and it is also the most commonly used. Other methods usually require commission staff to follow up to get additional information from the complainants. So with that, now we've talked about who can file a complaint, against whom a complaint can be filed. Now we're going to really dig into this 4-step process. This is the complaint process itself. So this is the process created by the Legislative Assembly, and we summarize it in 4 steps. 1, initial review. 2, informal resolution. 3, a settlement opportunity and investigation. So you have kind of 2 steps combined there. And 4, ultimately commission action. The commission has adopted the same process within its complaint rules. I already talked about those. Those are available in the Administrative Code, Article 115. That the statute has, they're very similar. There is some nuances to that. The commission is required by statute and its own rules to notify a respondent within 30 days that a complaint has been filed against a respondent. A complaint may resolve at each of these 4 steps, along the way in the process. However, if it resolves at one step, it doesn't move to the next. So if you attended our previous complaint webinar, you'll notice that there's some additional content here and there's some additional steps that need to be taken. So with that, I'm going to hand it over to Mr. Carpenter to walk through the steps and the changes that have happened in these steps.
Thanks, Rebecca. So we'll start at step 1, which you see is initial review. So at this step, the commission staff initially reviews a complaint to determine 2 main things. First, if the commission has complaint jurisdiction over the respondent, this is the commission's personal jurisdiction, and 2, if the commission has authority over the conduct alleged in the complaint, and this is the commission's subject matter jurisdiction. Under the Century Code, the Ethics Commission can summarily dismiss a complaint at this step if 4 things are present. First, it does not fall within the commission's jurisdiction, either personal or subject matter. 2, it's insufficient to identify a possible violation. 3, it fails to comply with rules adopted by the commission. Or 4, it was submitted in bad faith. The 4th option was added by the commission in 2025 to weed out complaints that can be filed with an ulterior motive. The rule took effect on April 1st of this year, and we'll talk about it later in the presentation. Another piece new to the complaint process is that a respondent may file a motion to dismiss at any time, asserting one of those 4 criteria applied to the complaint, and the commission should dismiss the complaint for one of those 4 or multiple of those 4 reasons. In previous iterations of the complaint rules, the Ethics Commission delegated the authority to summarily dismiss complaints to the executive director. In practice, the commission would direct the executive director to actually summarily dismiss the complaints. The commission formalized its practice of directing the executive director to do that and moved that authority to summarily dismiss complaints back to the commission itself within its rules, with the latest amendments to the complaint rules. So to initially review a complaint, commission staff review the information submitted with the complaint. We sometimes review publicly available information and other information upon request if needed. For the lawyers on the webinar today, this process is similar to a court reviewing a motion to dismiss under a Rule of Civil Procedure 12b6 standard. Commission staff look for specific facts when assumed to be true, plausibly creating an ethics violation. Under the commission's rules, if the complaint is summarily dismissed, the complainant used to have 30 days from notice of summary dismissal to appeal the summary dismissal to the commission. In practice, it actually operated like asking the commission to reconsider the summary dismissal. The commission removed this appeal from a summary dismissal in the latest amendment to the rules. Now it's simpler. If a complainant has additional information they want to share with the commission, they can just go ahead and refile the complaint with that additional information. So if a complaint moves on and is not summarily dismissed, it moves to step 2, which is informal resolution. At this stage, the commission must offer the complainant and the respondent an opportunity to informally resolve, meaning settle the complaint. If either party does not want to engage in the informal resolution process, the complaint moves to the next step. At this stage, the respondent is also provided a copy of the complaint or written summary. The respondent then may respond to the allegations in writing within 30 days if he or she wishes. This informal resolution process begins when commission staff send both the complainant and the respondent a form to fill out regarding informal resolution. That form asks whether the individual wishes to engage in informal resolution. It also requests some logistical information, and it does request what they believe a reasonable resolution of the complaint would be. Commission staff will then conduct an informal resolution acting as a third-party neutral. The informal resolution process can take place in a variety of ways. Some examples include going back and forth through formal written communication, speaking with both parties either in person or on the phone, having a formal mediation conference, having an electronic mediation conference. However, if the complaint is confidential, it complicates having a face-to-face conference with that complainant. Commission staff will then act as a go-between for the confidential complainant and the respondent, communicating the respective sides' positions. The process can take a few months when it is through those written position statements or when you are dealing with a confidential complainant. Both parties may be accompanied by legal counsel in any informal resolution proceedings, and if informal resolution is successful, commission staff will have the parties sign an agreement. The complaint is then closed, and the complaint and the informal resolution remain confidential, unless the parties in some way agreed to a form of confidentiality waiver as part of that informal resolution. However, big disclaimer here, informal resolution is rarely successful. It is mostly time-consuming for everyone involved, including for us as commission staff to facilitate it. If informal resolution is unsuccessful, or if the complainant or respondent does wish to proceed at any point, the complaint will move to step 3 in the process. A 2025 amendment added language to North Dakota Century Code Section 546607 stating, quote, if the informal resolution process between the respondent and the complainant is unsuccessful, the commission may work with the respondent to settle and close the matter, unquote. This begins step 3. The commission implemented this new language through its rules, requiring any settlement be made pursuant to settlement guidelines adopted by the commission. The commission adopted these complaint settlement guidelines on July 16, 2025, prior to the rollout of the new rule to provide consistent and even-handed settlement offers across all complaints. The settlement guidelines are available on the commission's website, and they define the general criteria for settling all complaint matters and provide specific criteria based on the type of ethics violation at issue. One of the general criteria in the settlement guidelines requires a respondent to waive confidentiality of the complaint and the settlement agreement. The commission included this requirement because it believes the principle of open, ethical, and accountable government requires the public to have access to the results of the commission's activities. This waiver of confidentiality factor is non-negotiable in the settlement process with the commission. To facilitate the settlement process, commission staff will do a settlement assessment for the commission and receive direction from the commissioners and approval on how and when to settle a complaint. A complaint may be settled before an investigation, during an investigation, or at any time before the commission takes final action on a complaint. For this reason, the settlement opportunity and investigation stages are combined into one step at step 3. So let's talk a little bit more about the investigation side of step 3. At this stage, at step 3 in total, the complainant no longer plays a role in the complaint process once it proceeds to an investigation in step 3. The commission solely takes over at this point. However, the complainant may be a witness in the investigation if they have independent knowledge of the facts at issue in the complaint. The Century Code states the commission may have its staff investigate the allegations in a complaint or engage an outside investigator to investigate. The commission's complaint rules state, quote, the executive director shall determine the manner in which the complaint will be investigated, unquote. The executive director can also refer the matter to an outside attorney or investigator with the approval of the commission under these rules. Section 546608 sub 3 of the Century Code states, quote, the commission may require the testimony of a witness or the production of a book, record, document, data, or other object at any of the commission's investigator interviews or proceedings held in connection with the investigation of a complaint, unquote. The commission often requests individuals make themselves available for interviews and to provide documents. It's important to note the authority of the commission to request these interviews, documents, records, or other evidence is not an open records request. Commission requests exist outside that process under Article 14 of the Constitution and that section of the Century Code that I quoted earlier. If the commission requests confidential records from another government entity, the commission is also required to keep those records confidential when they are received under state law. So what could an investigation by the commission include? Well, the commission's rules give examples of what an investigation may entail. That includes reviewing any documents provided to the commission by the complainant or the respondent, reviewing publicly available documents or documents maintained by the state, requests for documents from individuals or entities with knowledge or relevant information, written interrogatories, which are questions submitted to individuals or entities with knowledge or relevant information to the complaint, interviews with legislators, employees, or other appointed or elected officials, interviews with the complainant and individuals identified the complainant as having knowledge or relevant information, interviews with the respondent, and any other information deemed relevant to the commission's investigation. So at this point, it's important to discuss how the commission handles complaints that contain allegations of criminal conduct. The Legislative Assembly changed this process in statute in 2025. So we know the commission has authority to investigate alleged violations of any state law related to transparency, corruption, elections, and lobbying. Because of this broad directive, criminal statutes in those four areas exist. In 546608, the Legislative Assembly created a process for the commission to follow when complaints make allegations of criminal violations. The statute used to require the commission to make a criminal referral once it had a belief the complaint contained allegations of criminal conduct. The commission now has the discretion to decide whether it will refer that potential criminal conduct. It is no longer mandated to do so. Once the law enforcement agency or prosecutor accepts a referral, the commission must pause its review until the referred matter is complete or no action is taken within 60 days by the law enforcement agency or the prosecutor. The 60-day clock is a new amendment to the statute. Previously, the commission would have to wait, sometimes many months, when no action was being taken on the referral. Once the criminal review and/or a prosecution process has completed, the commission may need to conduct a further investigation or review to complete the ethics complaint process. There is a huge misconception that a criminal referral completes the commission's process. However, criminal and ethics proceedings are separate and distinct. So let's jump back into the process at step 4. The steps for commission action have changed slightly. The Legislative Assembly added language to the Century Code which states, quote, "Upon completion of an investigation, the executive director shall prepare a report and recommendation to the commission to close the matter or issue an alleged violation. The commission may issue an alleged violation, require additional investigation, or close the matter," unquote. The commission believed to implement this statutory language, it required an additional report from commission staff, which the commission called a preliminary report and recommendation in its rules. At the end of an investigation, the executive director will prepare a preliminary report and recommendation for the commission to close the matter or issue an alleged violation. The preliminary report and recommendation will outline some details from the investigation, but will not be a complete report of the entire investigation to conserve commission human resources. It is comparable to a complaint and affidavit of probable cause in a criminal proceeding. Under the commission's rules, once it receives a preliminary report and recommendation, it may use it to issue an alleged violation, require additional investigation, or close the complaint matter. An alleged violation is, quote, "a formal written allegation issued by a majority vote of the commission which alleges a respondent engaged in an ethical violation," unquote. If the commission requires additional investigation, another preliminary report and recommendation is necessary to move the complaint forward or to close it. The commission has already used the preliminary report and recommendation process to close a number of complaint matters since it started implementing it. This has conserved commission resources as complaints are no longer required to go through the entire complaint process. But let's, for the purposes of this webinar, assume that one is required to go through the entire process. Once the commission issues that alleged violation, commission staff must then prepare a final report and recommendation. The final report and recommendation expands on the preliminary version by including all the written findings from the investigation and the executive director's recommendation to the commission for how to resolve the complaint matter. The final report and recommendation prepared by the executive director will summarize the investigation's findings and incorporate any findings by outside counsel or an investigator if one was used for the investigation. The report will also include any relevant information by reference or attachment found through the investigation. Now, it's important to discuss the complaint process in statute because there it does not include much for procedure for commission action. It simply states the respondent may respond to the commission in person or in writing and may be accompanied by legal counsel. The commission felt it was important to formalize a procedure for this process and did so in the latest amendments to the complaint rules. The new rules outline the investigation file, including relevant documents, interview transcripts or recordings, and the respondent's written response if the respondent submitted one, and any other evidence obtained must become the record for the complaint. The respondent must receive the final report and recommendation and the complaint record at least 10 days before the commission considers the matter at a meeting. In practice, the respondent is given much more time to respond to the final report. The respondent can respond in person and in writing if the respondent chooses, this gives the respondent an additional opportunity to respond than what's actually required in statute. If the respondent does submit a written response, it must be 5 days in advance of the meeting. And then when that meeting takes place, the commission will conduct a hearing on the complaint in an executive session. The chair of the commission or the chair's designee acts as the hearing officer and determines the order of presentations and the time allotted for presentations by the executive director and the respondent. The hearing officer determines all procedural matters necessary for an orderly hearing and may administer an oath or affirmation to any witness providing testimony at the hearing. That hearing must be audio or video recorded or reported by a certified court reporter and may take place via reliable electronic means at the discretion of the hearing officer. The respondent may absolutely be accompanied by legal counsel if they have an attorney. And following the hearing, the commissioners will deliberate outside the presence of the respondent's attorney, and commission staff who worked on the investigation. The commission determines if an ethical violation occurred and determines what penalty, if any, to impose, or whether to refer the matter to another entity. And finally, the commission memorializes its decision in a written order, which is provided to the respondent. The commission formalized this hearing procedure to ensure everyone knows what the process will be and to create a clean record should the respondent appeal the commission's decision to district court. It's important for the court to have something to review should an appeal be taken to the court. So let's talk a little more about that process. After the decision, following a determination an ethical violation occurred, a respondent has the ability to appeal the commission's finding to district court by statute. And that's the ability to appeal to the district court where he or she is a resident. And that statute is section 546610. The commission attempted to fix an issue with the appeal statute, but it was part of a bill that failed during the last legislative session. The statute assumes every respondent will be a resident of North Dakota. However, for instance, a lobbyist or contributor may be an out-of-state resident. It's unclear by the text of the statute where these respondents would appeal the commission's decision. Now, if the respondent does not appeal or the court affirms the commission's findings, the finding is no longer a confidential record under statute. The commission will then make its findings of an ethical violation public and publish those on its website. So I'm going to turn it back over to Rebecca to talk about some new nuances to the complaint rules and the statutes.
All right. So before we wrap up today, there are two additional new things that we want to talk about that came out of legislative session, the 2025 legislative session, or subsequent ethics commission rules. The first one is time management standards. This was a new statute that was adopted or was passed during the 25 session, and it is section 5466 10.1. And it states that the Ethics Commission, or the Commission, shall adopt rules for the efficient and timely disposition of complaints from receipt to resolution. So in light of that statute, the Commission then adopted what it's calling time management standards. Those time require three things. One, dismissal within 60 calendar days if the Commission determines it does not have jurisdiction. Two, that the Executive Director is to report on complaints that have been pending for more than 180 days, effectively 6 months, during meetings in March, June, September, and December of each year. So effectively, this is requiring the Executive Director to report on those complaints that are pending more than 6 months at each of the Commission's quarterly meetings. And last, the Executive Director has to report on complaints that have been pending more than a year, 365 days, at every regular meeting. Now, I do want to note that these reports that happen on this time, pursuant to this time management standard, because it relates to complaints, this does happen in executive session. So you won't see that if you watch the Commission's meetings. It happens in executive session. So that is something that the Commission has adopted in order to help review and facilitate the efficient and timely disposition of complaints. The last thing that the Commission has adopted that is new relates to bad faith complaints. So in response to seeing complaints that are submitted in bad faith, the Commission adopted a process in order to deter bad faith complaints. If the executive, so what this process is that if the Executive Director or a Commissioner determines a complainant may have filed a complaint for the purpose of harassing or impugning the reputation of a respondent, or has otherwise filed a complaint in bad faith, the Commission must be notified. Then, upon notification, the Commission may then order the complainant to show cause why the complainant was not submitted in bad faith. The complainant may respond in writing, or he or she may request a hearing before the Commission. If after notice and a reasonable opportunity to respond, the Commission determines that the complainant actually submitted a complaint in bad faith, the Commission may impose an appropriate sanction on the complainant. The Commission notes a sanction must be limited to the purpose, and it must be sufficient to deter repetition of that conduct or to deter comparable conduct by others who are similarly situated. In other words, it needs to be measured. For instance, some of the sanctions, or for example, some of the things the Commission may do in this instance, is that sanctions may include dismissal of a complaint that was filed by a complainant. There may be a formal reprimand of the complainant. The complainant may be designated as a vexatious complainant and require prior approval before filing or submitting complaints in the future. Or the complainant may lose the ability to participate in that informal resolution process that Mr. Carpenter talked about previously. So all of those things are options and ways that the Commission is attempting to address when a complaint may be submitted in bad faith. Now, that wraps up kind of our walkthrough of the new things that have happened. Hopefully you caught those new stickers in the bottom of those slides. We now can open the floor in the chat to some questions. However, before we take questions, I wanted to let you guys know two things. One, this webinar is going to be available on the Ethics Commission's YouTube channel. Our handle is at ND Ethics Commission. You can access it through the Commission's website. You'll also receive an email with the slide deck later this week. You will also receive a post-attendance survey email as well. So hopefully you can comment on that or respond to that and give us some feedback on what you learned from today. But with that, we're going to open the floor. It looks like we have about 7 minutes maybe for any questions that individuals may have. Not seeing anything in the chat. We'll give it just a few minutes for those of you who might be thinking of something or that you heard something along the way and you made a note and you just need to pop it into the chat as well. Well, it looks like somebody has their hand up. Patty, do you think you can allow that person to unmute their microphone for them? Give us just a second.
Okay, hopefully, can you hear me?
Yep, we can.
Yeah, I tried multiple times to get into the chat to type something and it wouldn't allow me to do that. I don't know if other people had that problem, but okay, maybe it looks like it's but my question is this, I worry about due process with the confidentiality of the complainant. I worry about due process for the respondent. Does the respondent have any opportunity during the process to either cross-examine the complainant or cross-examine any of their witnesses? That's my question. Thank you.
So David, thank you for that question. When it comes to due process, there is the hearing where, as executive director, I am functioning as presenting the evidence, or whoever it might be an attorney in my shoes at that point. So they do have an opportunity at that point to cross-examine witnesses, to review documents, to present questions, present their own witnesses at that point or own documents. When we talk about a confidential complainant, they may provide information that is then forwarded to the respondent. We do maintain the confidentiality, but we don't have the same concerns that we do in the criminal context. I'm just looking at Logan to make sure that I'm accurately stating that.
So we talk about the distinction between the criminal process and the complaint process, because the Ethics Commission complaint process, and I think this is maybe what your question was getting at a little bit, the confrontation clause under the U.S. Constitution doesn't apply because in the ethics process, imprisonment is not a factor. That's not at issue. So that particular constitutional right doesn't attach to Ethics Commission respondents to essentially cross-examine the complainant. But in practice, really, the complainant is more of somebody that that would call like the police tip line or call 911. They might not be a witness to the proceeding, but they might have some information to start the proceeding. In most contexts, the complaints that I've worked on since I've been at the commission, the complainant really is not a witness very often.
Yep. Great question, though.
Okay, thank you.
Any additional questions? Looks like we have one more, which is the question presented was, may a bad faith complainant be sanctioned monetarily? That is not something that the commission answered necessarily in its in its rule. I believe that they discussed it and we're concerned about having a monetary sanction that could deter people, potentially deter too much from having somebody file a complaint. But I don't necessarily think it's precluded, but not something that the commission would necessarily go to first. Also, good question. Anything you want to add to that? I'll give the chat just another minute in case anybody has something that they want to pop in there. But with that, I want to thank everybody for attending today. Hopefully you got a little bit of an overview specifically on the changes that happened in 2025 that really went into effect in April of this year. So thank you again for joining us today, learning about the commission, learning about the changes to our process. Feel free to visit our website, check out the other webinars, look for future webinars in the future, and then you can also sign up for our mailing list. Many of you guys are already on that, and that's why you had the information for today. So thank you all, and have a wonderful Tuesday.